There are mornings in a courthouse that feel indistinguishable from every other morning, the same polished floors, the same muffled footsteps, the same air of practiced routine. The Tampa courthouse had hosted thousands of such mornings. Businessmen in pressed suits, nervous defendants gripping folders, clerks moving between rooms with stacks of paperwork. Nothing about that particular Tuesday suggested it would be any different. The docket was thin. Before we move on, don't forget to hit subscribe button. The case on the calendar was a business dispute, the kind of civil hearing that gets resolved in 2 hours and forgotten by lunch. Nobody arrived expecting history. Nobody arrived expecting fire. Pam Bondi had been inside courtrooms longer than some of the clerks had been alive. She knew how they breathed, how they shifted, how a room full of strangers could collectively hold its breath without realizing it. She pushed through the solid wooden doors the way she always did, not with arrogance, but with the quiet confidence of someone who had long since stopped being intimidated by the architecture of power. Her briefcase was in one hand, the lapel of her blazer pinched between the fingers of the other as she straightened it. She scanned the room out of habit, the bench, the gallery, the clerk, the bailiff standing near the wall with the particular bored alertness of someone waiting for a shift to end. Nothing unusual. She moved toward the defendant's table and set her briefcase down with a soft, deliberate click. She didn't notice him staring right away. Before we move on, don't forget to hit subscribe button. When she did, it wasn't his eyes that told her something was wrong, it was the quality of the silence that followed his gaze. Judge Robert Thompson was a man of few ceremonies and fewer words. He had been on the bench long enough to have earned a reputation for bluntness that some called efficient and others called rude, depending on which side of his rulings they had landed on. He was not the kind of man whose attention wandered. When he looked at something, he meant to look at it. And he was looking not at her face, not at her briefcase, not at the documents she was arranging on the table. He was looking at her neck. More precisely, at the small gold cross resting just below her collar. The shift in the room was subtle at first, the kind you register in your chest before your mind catches up. The clerk's pen stopped moving. The bailiff's posture changed by a fraction of an inch. A woman in the gallery who had been whispering to her companion went quiet. Then Judge Thompson cleared his throat, leaned forward the way a man does when he has already made a decision and is merely announcing it, and spoke. His voice was not loud. It didn't need to be. "Miss Bondi," he said, "I'll remind you that religious emblems have no place in this courtroom." Pam looked up from her papers slowly. She didn't blink. She didn't flush. She didn't reach for the cross. She simply looked at him the way a surgeon looks at a complication, not with panic, but with immediate, focused assessment. "Your Honor," she began. That cross, and Thompson cut her off cleanly, without raising his voice, the way people do when they are accustomed to not being interrupted. "It breaches this room's neutrality," he said. "Remove it, or I will issue a fine." A soft, collective intake of breath moved through the sparse gallery. The clerk's eyes traveled from the judge to Pam and back again. Fines were not unusual in courtrooms. Judges had imposed them for tardiness, for outbursts, for phones left on. But no one in that room could recall a judge ordering an attorney to remove a piece of jewelry on grounds of religious neutrality. It was the kind of thing you read about in law school as a hypothetical, the kind of scenario professors invented to test where the edges of judicial authority actually lived. Before we move on, don't forget to hit subscribe button. Now it was happening in real time. In a business dispute hearing on a Tuesday morning in Tampa, and every person present knew they were watching something that mattered, even if they couldn't yet say exactly why. Pam did not reach for the cross. Her hands settled flat on the surface of the table, calm and deliberate. "Forgive me, Your Honor," she said, "but this cross is no different from a wedding ring or a locket containing a photograph. It is personal. It causes no disruption to these proceedings." Thompson's expression didn't shift. "In my view it does," he said, with the exhausted patience of someone who considers the matter already settled. "Remove it, or the fine stands." Here is what most people in that gallery did not know. Pam Bondi had not walked into that room unprepared. She rarely walked into any room unprepared. The cross she wore was not new. She had worn it for years, through cases that made headlines and cases that did not, through victories and defeats, through moments of profound personal difficulty. It was not a statement. It was not a performance. It was simply hers. And the moment Judge Thompson told her to take it off, something shifted in her, not into anger, but into a particular clarity of purpose that anyone who had ever faced an injustice, small enough to be ignored but large enough to matter, would immediately recognize. She straightened in her chair. "Your Honor," she said, "I would like to formally object and argue this matter on the record." Thompson's brow lifted slightly, as though she had said something mildly amusing. "This is a business dispute hearing, Miss Bondi," he replied, "not a platform for personal grievances." Pam's expression didn't change. "And the First Amendment," she said evenly, "does not pause for anyone's convenience." That landed. She could see it in the slight tightening around his eyes, the barely perceptible pause before his next breath. The court reporter's fingers hovered over her keys. The room had stopped pretending to be indifferent. "You're penalizing me for a cross," Pam continued. "So let us examine that legally, Your Honor, because I would very much like to understand the precedent on which you are relying." Thompson exhaled slowly, massaging his temples with 2 fingers. And Pam took the gesture for what it was. The first sign that he had not anticipated resistance of this particular kind. He had expected embarrassment. He had expected compliance. He had not expected a seasoned constitutional attorney to pull a single sheet of paper from her briefcase and set it gently on the table in front of her, smoothing it once with her palm, before looking up at him with an expression of complete, unwavering calm. "Before we move on, don't forget to hit subscribe button." She did not rush. She let the silence stretch. She let every person in that gallery feel the weight of what was happening before she opened her mouth again. Then she spoke. "Tinker versus Des Moines, 1969, she said. "The Supreme Court ruled that constitutional rights do not evaporate inside public institutions, not in schools, not in government buildings, and not in courtrooms." She let that settle for a moment before continuing. "West Virginia State Board of Education versus Barnett, 1943. The court held that compelling any individual to abandon a symbol of personal belief constitutes a violation of their constitutional protections. So, Your Honor, shall I go on, or would you like to reconsider the fine?" The drumming of Thompson's fingers on the arm of his chair was the only sound in the room. He was a man of long experience and considerable pride, and both of those things were working against him now. He knew those cases. Every person with a law degree in that room knew those cases. And every person in that room also knew that he had no answer for them. Not a legal one, not an honest one. "This isn't a debate on religion," he said at last, but the words landed flat and hollow, and he seemed to know it even as he said them. Pam cocked her head slightly. "Then why did you start one, Your Honor?" Gasps scattered through the gallery like startled birds. Thompson's face darkened. "Enough," he said sharply. But the authority in his voice had developed a crack, thin as a hairline fracture, but visible to everyone paying attention. Pam leaned forward just slightly, her voice dropping to something almost conversational, which somehow made it more devastating. "Respectfully, Your Honor, I will stop when you provide me with a legal basis for this fine." She paused. "I have yet to hear one." The silence that followed was of a different quality than any that had come before it. It was not the silence of a room holding its breath. It was the silence of a room that has just watched someone win. Thompson glanced at his clerk. "Note that the fine is under review," he said. Pam allowed herself the smallest of smiles. "I'll take that as a start," she said. But she was not finished. She had not come this far to simply let a man retract a fine and call it resolution. She pressed forward, methodically, patiently, the way a river presses against a dam, not with violence, but with the accumulated weight of everything behind it. She pointed out the defense attorney who had worn a pink breast cancer awareness ribbon mid-trial without objection. She pointed out the official pins and commemorative lapel badges that passed through Thompson's courtroom regularly without comment. She laid out the inconsistency the way a mason lays bricks, one on top of another, each one reinforcing the last, until the structure was undeniable. Thompson's grip on the desk tightened. He had walked into this hearing as its unquestioned authority. He was now watching that authority dissolve in real time, in front of witnesses, and there was nothing he could reach for that would stop it. Pam gave him the moment he needed. She did not gloat. She did not raise her voice. She simply looked at him steadily and said, "If you choose to uphold this fine, Your Honor, I will file an appeal before the ink is dry, and I will not be filing it quietly." A judge fining a woman for wearing a cross in an American courthouse, I think you can imagine how that story travels. Thompson's nostrils flared. The pride in him was fighting the reason in him, and the room could see the battle plainly. Then, at last, he exhaled a sharp, controlled breath that contained everything he couldn't say and spoke. "The fine is withdrawn," he muttered. Pam thanked him, sincerely, without sarcasm, without theater. But she was not done. Not in the way that mattered. Because what had happened in that courtroom was already bigger than the fine, bigger than the cross, bigger than any single ruling a single judge could make or unmake. The court reporter was still typing. The people in the gallery were already reaching for their phones. The story had left the building before Thompson even raised his gavel. Outside, word moved fast. A journalist covering an unrelated case nearby had heard enough through the walls to know she had a story. Within an hour, a local outlet carried the headline, "Florida Judge Tries to Fine Lawyer Over Cross." It backfires. By evening, the story had legs that no one, not Pam, not Thompson, not anyone in that courtroom, had fully anticipated. Legal commentators on networks across the political spectrum weighed in. A constitutional law professor at Georgetown called Thompson's position legally groundless and historically illiterate. A prominent defense attorney posted a detailed breakdown of the precedents Pam had cited, and it was shared thousands of times before midnight. Pam sat in her office that night, phone buzzing steadily on her desk, and felt something she hadn't expected. Not triumph, exactly, but a kind of sober clarity. She had not gone to that courthouse to make a point. She had gone to represent a client in a business dispute. The fight had come to her, and she had met it not because she was looking for a moment, but because backing down from it would have meant something she wasn't willing to accept. She thought about the lawyers who appeared before Thompson regularly, the ones who might not have her resources or her platform, the ones who might have quietly unclasped a necklace rather than face a fine they couldn't afford to contest. That thought sat with her more heavily than any headline. Thompson, meanwhile, was not through. She had known he wouldn't be. Men who lose publicly in rooms they consider their own rarely accept the loss gracefully. The following morning, her assistant Sarah came in with a tablet and a carefully neutral expression, the expression of someone delivering news they wish they didn't have to deliver. The Florida bar had issued a statement, cautious, measured, but pointed. It acknowledged that attorneys possessed expression rights, while simultaneously emphasizing respect for presiding judges. It was, Pam recognized immediately, not a neutral statement. It was a warning dressed in diplomatic language, and it had Thompson's fingerprints all over it. She set the tablet down and told Sarah to tell her the rest. "There was a formal complaint," Sarah said softly, "filed against Pam. Disruptive conduct, defiance of judicial authority, behavior unbecoming of a court officer." Pam read it and laughed a short, dry sound without much humor in it. Then she got to work. She called Emily Carter, a legal journalist she had known for years, a woman with a reputation for precision and a complete absence of fear when it came to calling out judicial overreach. She laid out every detail: the cross, the fine, the retraction, the complaint. Emily listened without interrupting. Then she exhaled. "He's going after you for making him back down," she said. "Exactly," Pam replied. "And I need it public before he can make this look like a procedural dispute." Emily told her it would air the next morning. Pam hung up and turned to Sarah. "Draft a statement," she said. "Not a defense, a declaration. Frame it around what this actually is, a use of institutional power to silence someone who refused to be silenced." The next morning arrived with the velocity of a verdict. Emily's segment ran at 7. By 9, it had been picked up by outlets that rarely agreed on anything. By noon, the Florida Judicial Review Board announced it would open an inquiry into Judge Thompson's conduct for potential ethical violations. Before we move on, don't forget to hit subscribe button. Thompson appeared briefly outside the courthouse that afternoon, camera lights catching the tight set of his jaw, and said in a clipped, careful voice that he had always acted in the interest of courtroom integrity and would cooperate fully with any review. He said it the way a man says something when he knows the room has already decided. Pam watched the clip on her phone and said nothing. The review board's inquiry would take weeks. Its outcome, whatever it turned out to be, would matter but not as much as what had already happened. Thompson had not merely lost a legal argument in his own courtroom. He had demonstrated, in front of witnesses and on the public record, that the authority vested in a judge could be turned against the very principles that authority was meant to protect. And Pam had demonstrated something equally important, that it was possible to stand in the path of that misuse and refuse to move, armed with nothing more than knowledge, composure, and the willingness to say out loud what everyone else in the room was only thinking. She sat at her desk late that evening, the city quiet outside her window, and thought about the cross still resting against her collar. She hadn't taken it off, not when Thompson ordered her to, not when the fine was issued, not when the complaint was filed. It was still there, small and gold, and entirely ordinary, meaning everything it had always meant and nothing more. She hadn't worn it to make a point, but a point had been made, and it was this: that rights are not preserved by institutions alone. They are preserved by the people inside those institutions who refuse, in the moments that matter most, to pretend that the wrong thing is acceptable simply because someone with a title has decided that it is. Pam Bondi had not gone looking for that fight, but she had finished it, and in finishing it, she had ensured that the next person who walked into that courtroom or any courtroom wearing something that belonged to them would do so with a little more protection than they'd had the day before.